Good evening, everyone. I'm going to call the County Services Committee meeting of the Washington County Quorum Court to order for this evening. And I believe Justice Rios Stafford's up to do us the honor of prayer and pledge. Justice Rios Stafford.
Thank you, Judge. On this day, let us pray for peace in the Middle East and around the globe, especially those countries and regions that are at war. We pray that peace prevails, that all hostages are released, and that all innocent civilians are spared from violence, terrorism, and warfare. Let us pray that humanitarian aid reaches those who need it, that we are all on this earth able to follow the path of peace, resolve our conflicts through mutual understanding, see each other as brothers and sisters, and seek reconciliation. Amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Justice Rios Stafford. And with that, we're going to move into the adoption of the agenda. Do we have any amendments to the agenda? If not, I'll entertain a motion to adopt the agenda. I have a motion to adopt the agenda by Justice Lyons, a second by Justice Dean. All those in favor? Aye. Those opposed? The agenda has been adopted. With that, we're going to move right into our monthly reports. First up, we're going to hear from the juvenile detention from Director Tinsley. Director Tinsley, good evening.
In the month of September, we had 24 intakes, with the average length of stay being 5.38 days. The average daily population for September was 10.60. The highest number of intakes were battery in the 3rd degree, misdemeanor at 4. Of the 24 intakes of Washington and Madison counties, 14 were from Division 3 and 10 were from Division 8. There were no transports for the month of September. Are there any questions that I may address at this time?
Questions for Director Tinsley? Thank you, sir. We sure appreciate you.
Thank you, sir. I appreciate it so much.
Mm-hmm. Next up, the Sheriff's Office report. Sheriff Cantrell. Good evening, sir.
Good evening, Mr. Chairman. Thanks for allowing me to come forth and present the report. I'm Jay Cantrell, your Washington County Sheriff. Our calls for service, if everybody's got this page, our calls for service are up a little, but we don't find that abnormal, and so we're still monitoring it to see if it develops into a long-standing trend. Detention intakes were up a few for the month, but we know that this month now runs from the 16th to the 15th, so there are some anomalies that might come from the prior year, but we are seeing overall probably we'll have about 10,000 intakes this year. We did send 60 to prison this past 30-day reporting cycle, 30 last Monday, so whenever they call to send 30 to prison, it takes all hands on deck to get the cars staffed and the van staffed and the people up at early in the morning to get them ready to dispatch down to the Malvern to the intake unit. But we were happy to get rid of 60. We've still got about 95 state new commits waiting to go down. So, but that did help some. You can see our average high count there at 808. Our state prisoner average daily population for this reporting period was 170. Federal prisoners at 74, but we expect they've had a lot of sentencing, so we expect several of those to start moving out pretty quickly on our federal numbers. Pre-trial still 495, so a lot of people still waiting in the county jail to get to their court date. Currently at this moment in time, there are 776 people in the county jail. So I'd be happy to answer any questions. I know you all have questions about different things, so I'll try to answer them. Anybody's got anything?
Questions for Sheriff Cantrell? Justice Coger?
Thank you, Judge. Sheriff, I'm just wondering, and help me remember, on the county commit, the average daily population, are those the misdemeanors that the district court sends?
Not necessarily misdemeanors.
Okay.
People can be sentenced to the county jail from circuit court as well.
Right.
Just can't be sentenced to the county jail for longer than a year. So some people from circuit court could get a 90-day or a 180-day commitment to the county jail. So
Okay. And do you know how many federal bed days we have this year,
this year, not
to date, or to the end of the month?
Not off the top of my head, but I can get that number. I think that we can probably get it before the end of the meeting.
Okay. Also, I was wondering, do we have any prisoners from Madison County still in our jail, or are they all cleared?
We have one
One, okay.
that we're holding for them as a courtesy. They're still paying, but we only have one Madison County prisoner.
Okay. That's all I had. Thank you very much.
Yeah, you're welcome.
Additional questions for Sheriff Cantrell? Thank you, sir.
Thank you, sir.
We appreciate you. With that, we're going to move into the new business portion of our meeting. And first up, we're going to hear from Director Kristen McAllister, who runs our crisis stabilization unit that we host here in our county. Director McAllister? Push the button on the right, I believe. There you go.
Okay. Hello. So I'm Kristen McAllister. As Judge referenced, I'm the director of the Crisis Stabilization Unit here in Fayetteville. So for those of you that might be unfamiliar, we are a 16-bed behavioral health unit with a primary focus on working with our partners in law enforcement to bring individuals that are experiencing a behavioral health crisis to receive treatment as a diversion from incarceration, emergency departments, and psychiatric placement at acute hospitalization. Not only are we open to law enforcement, but we're also open to the community at large. So we receive referrals from just about anywhere in the community. So I had provided our state report, but I understand that it did not print correctly, or the version that I sent, or it didn't print correctly. So I don't know if I'm welcome to, I welcome any questions. I can also provide some information on our most recent state report from September, if that would be helpful.
We have it up on the screens behind us now
great.
where we can reference it, but I would think that what would be beneficial for this group is to maybe just review the last few months that we've been through,
Sure.
and then maybe just give a general
Some
overview
highlights,
of the
yeah.
numbers you're seeing now.
Okay, great. So as you can see on the screen here, so we have July through September, so we have started kind of our new quarter here. So we did have our highest referrals in the month of July. We had 97, so that was by far our highest since opening. And then I'll just go over September numbers because those are the most recent. So we had 82 referrals in the month of September. 20 of those were from law enforcement, and when I say law enforcement, I mean everything from a patrol officer to a sheriff's deputy to maybe somebody who's being referred by a court system. So we've had 20 of those referrals. And then our highest referral source for the month of September was 30, and that was self-referrals. So individuals hearing about us and calling us directly. We were able to recommend 59 individuals for an in-person assessment. And so just to explain that piece a little bit, so we did have 82 referrals. 59 of those folks, we said, just based on a phone call, sounds like you're an appropriate person to come on down to the CSU so that we can do a triage and an admission with you. And then over the month of September, we were able to admit 35 individuals. So you're probably wondering, which I think this is a good point to make, if we invited 59, how come only 35 admitted? So when we invite somebody to an admission, we often see, or not often, but we do see individuals having trouble get to our facility, or maybe they change their mind after we've invited them in. So that can kind of explain the difference between the number of admissions we have and the number of folks referred. Most of the time, individuals that are presenting to our door are admitted. There are occasions where somebody presents, and maybe it's a more acute situation upon presentation, so we might have to refer them to other resources in the community, but most of the time they are admitted following a presentation. And I'm thinking one other point just to mention, so we are a short-term facility. So individuals that come to us, they typically, we're a 72 to 96 hour, 96 hours being our highest, kind of our limit in terms of a length of stay. And on average for the month of September, folks stayed with us for a total of 56 hours. So those are kind of the highlights of September.
Who has questions for Director McAllister? Justice Lyons?
Not necessarily for the director, but could we get the Excel sheets emailed to us since it didn't come out in the packet very well?
Yes, we can get those forwarded to the Quorum Court for sure.
Thank you.
Justice Coger?
Thank you, Judge. Director McAllister, the reason I had asked you to come and give the report was one of the reasons was I think that the community needs to be thinking about the CSU, you know, not just out of sight and out of mind. And so I thought that would help. And also, if I'm correct, when we got the additional funding from Governor Sanders a few months ago, she directed the CSU to come up with some plans, you know, be more sustainable for when that funding expires next year at the end of June, I think. So, and the pilot plan that you had, I wonder if you could speak briefly about, you had, as I remember, you had three. You had the 23-hour crisis bed, you had the mobile outreach community-based crisis assessment, and the outreach support services. I think all those are great, especially if you could speak about you had extended hours, even some on the weekends, I understand, which you were going to try to do, and that there was Medicaid codes that had to be approved, and I'm wondering if that got approved, and I just think that would be beneficial for the community to hear about those and make them more aware of some of the services. And again, I thank you for coming to talk to us.
Oh, of course, yeah. So yes, to speak to the pilot programs. So as Justice Coger mentioned, the state with our funding, in order to receive those additional funds to get us back to $90,000 a month, they did request that we establish some pilot programs. So one of those pilot programs being a 23-hour observation bed. So to explain that a little bit, the Medicaid rates how Medicaid rates are currently set up, for anyone that doesn't stay at the CSU after midnight, we don't receive a daily rate from Medicaid for that individual. So we might receive a service rate, but we don't receive a daily rate. So to help kind of offset that, pretty much every CSU has elected to pilot a 23-hour observation bed. Those codes have not been turned on by Medicaid as of yet, but right now we're just in a process of kind of gathering information of how many individuals come to our facility that do stay less than 23 hours and individuals that stay less than 12, and then also pushing that as an opportunity to our community. You don't need to stay with us for 72 hours. Let's get you in the door and see what we can do in a short amount of time. And then the two other pilot programs, we had talked about doing mobile crisis assessment outreach, and so having a mental health professional go out into the community. Considering as a pilot, we would do select locations and provide a crisis assessment in the community. So having a mental health professional respond to the person in crisis to have that conversation, as opposed to them coming to us or having to make that phone call, we can go to them. So that is in the works. We're trying to kind of dot all our I's and cross all of our T's to make sure that is something that we can kind of carry through with. The third one is considering outpatient. So potentially having outpatient services from the CSU for individuals that leave the CSU when they are discharged. So most individuals that are leaving the CSU, those follow-up appointments can be quite a distance out in the future. We're looking at, in some cases it can be 6 to 8 weeks. And that's, with our partner community providers. So connecting them to a community provider. So thinking about, could we provide, a follow-up appointment at our facility a few weeks after them discharging to kind of bridge that gap between the CSU and outpatient care. So that's a summary of the 3 pilot programs that we're trying to get off the ground. Did that answer for you?
Yes, thank
Okay.
you. I will look forward to looking at the report when I can read it. Thank you.
Yes.
Justice Ricker?
Ma'am, can you tell me what kind of, you do with people in crisis, but under what circumstances do you deny them services? Under the influence of alcohol, drugs, or violent, or what?
That's a great question. So our services, and I guess I'll start by saying, we tend to serve the gray area. So we serve the individual that doesn't meet criteria for an acute hospital stay. So their services, they're agreeing to receive services, so they're voluntary, and they can maintain on an unlocked unit because our facility is unlocked. And then there's kind of that acuity, right, in terms of psychiatric acuity. Are they violent? Has that been an experience for them, in the short time, in them being referred to us? They would most likely not be a good fit for our facility because we are also a hands-off facility. Other reasons somebody might be denied services with us or maybe referred out is if they're in acute medical distress. So we are not hospital level, so we don't have the appropriate or the necessary medical equipment to address some of those needs. You mentioned intoxication. If somebody's not able to walk and talk and consent to services, we're going to ask them to be medically cleared before coming to us.
Okay, thank you.
Yeah, sure.
Justice Dennis?
Thank you, Judge. I hate to show my ignorance, but I don't know where you're located at.
We are not far from this building. We're actually just over, we're emerging, and I'm probably pointing in the wrong direction.
Well,
My
everybody's-
directions are not.
What
We're
I'd
over
really
at the
like
old
to
emergency
I really
management
would
building.
like you to say where it is so that it goes out to
Absolutely.
the community.
Yes.
As J.P. Koger said, a lot of people listen to this, and
Yes.
so I would like for you to say where it is.
So we're at 105 North Mill Avenue. We are in the old emergency services building for the county.
Okay?
Yeah. So
right.
we're at Spring and College, maybe just a block down.
Okay, thank you.
Mm-hmm.
And then, so people can come, walk-ins, is what I would understood? Otherwise, they come for help themselves.
Correct, right. So individuals, they can call us, and they can also walk to our, do a walk-in to our services.
Okay, well, I appreciate what you're doing, and very nice to have you
Absolutely.
come visit with us.
Yeah.
So, a good thing.
Other questions for Director McAllister? Justice Coker?
Thank you, Judge. I just want to say, Director McAllister, that I appreciate all that you do. And the CSU is so important to the community, and it's going to be so important to we have criminal justice reforms coming down the pipeline finally. It's going to be so important to that. If there's anything that this court can do to help you or to help the CSU anyway, just please let us know, because I want to be a part of that if we can.
I appreciate that.
Thank you.
Well, and I'll just, say open invitation if anybody wants to come, if you haven't been to the CSU and you'd like to come check it out and see what we look like and who we are and what we do, I'd really encourage it. It is a very different setting than I think most folks anticipate when they're, thinking about behavioral health services. So. I will not, no.
Thank you, Director McAllister. We sure
Absolutely.
appreciate you.
Sure.
And with that, we're going to move to item number 7 on the agenda, an ordinance prohibiting the use of compression release engine brakes in Washington County and for other purposes. Justice Dean, would you like to introduce this ordinance?
Thank you, Judge. I'd like to start with apologizing for calling it a Jake brake before. It is an engine combustion release brake, and very loud and very uncalled for. And the area that they're running in, it's been a rural area a long time. There are houses popping up every place. and I'm getting a lot of complaints. So, you know, you don't have to put a sign up if you don't have a problem. The signs will only go where there is a problem. So with that, I ask that we can move this along and get it passed and get the signs underway.
So I have a motion to pass item number 7 by Justice Dean. Does it have a second?
For the sake of discussion, I'll second the motion.
Okay. Justice Ecke will second the motion for the sake of discussion. Justice Lemming?
Well, I know you say that it don't have to have signs up, but if it's an ordinance, that means it's a law. That means it says all of Washington County. I used to own 16 chicken trucks to haul chickens for Tyson all over Washington County, Plum to Benton, Crawford, all around us. And Washington County is just, we've got hills everywhere. Yeah, they're not 5 miles long, but they're short and they're steep. Brake fatigue is a real thing, and it really happens. 18-wheelers coming off them little steep hills come down them sometimes fast, and they're permitted to run. In chickens and feed, you're permitted to run at 85,000 pounds. That's the law. They can do that. And I don't see it necessary to come up with an ordinance whenever there's already a state law 27-37-601. Every motor vehicle shall at all times be equipped with a factory-installed muffler or one duplicate factory specification in good working order and in constant order to prevent excessive or unusual noises at any additional smoke. That's a state law. Any police officer, state, federal, county, anybody that's got law enforcement can write a ticket on it already. It's a state law. And for us to say in this here that it says right in here that the safety, the public health and safety well is deemed necessary to the quorum court. That's backwards. We're endangering folks whenever we take away a jake brake from a semi, because that is a very important piece on a semi that we do not need to take away for the use of. And Washington County uses them on all their dump trucks. That's going to make our cost to work on them all the time more, because if you run them right and use them right, they're a very good tool. And we need to leave them alone. And all the new trucks today has new muffling systems on it. Yeah, there's some guys out there that needs the police. We got a law that says that needs the police to come talk to them. They are. But there's also noisy cars out there. There's also noisy motorcycles out there. So if we want to pick on noise, let's go in a different direction, get a noise law, and go that direction. But the safety is here for these semis to be, that's the reason they put them there, for the safety. So I'm going to be voting no, because it's a very important tool we need to leave alone. Thank you.
Thank you, Justice Lemming. Justice Ecke?
Thank you, Judge. My question is, who are the stakeholders? I mean, who are the trucks, if they have this on there? I mean, how can we tell them they can't use it? So I don't know if we could identify exactly who we're talking about. And then secondly, the enforcement mechanism. I don't know how we're going to do that and how you can identify this particular.
You'll hear it.
I know, but how do you identify the truck, the company or the truck that is violating that noise, and then hold them to a ticket? I don't understand how we're going to be able to process this. So if anybody else can answer those questions, but if all of the trucks have this mechanism on there, how are you going to get it off? I mean, how are you going to not use it if it is factory installed? Is it factory installed on the vehicles? I mean, I don't know. Thank you, Judge.
Justice Dean?
Thank you, Judge. Article 4 states that these signs will only be posted in locations there's a problem. You don't have to have a sign. So I don't know what the big deal is about it. If there's people being aggravated in my area and I'm getting calls for it, the engine compression brake, I don't hear that a lot, but we do hear it some, and in our area where it runs all day, these guys are running back and forth. It's not just a guy blowing by on a motorcycle and he's gone. They're there all day. And they're just aggravating people. They're not that necessary. I mean, how many brakes do you need? You got your foot brake, you got the Jake brake, now you want the engine brake. I mean, you know, it's, and it also states in here that if it's an emergency, use it. Even if it's posted, you can't. So if it's an emergency, they can use it. So I don't know what the big deal is.
Justice Lemmy?
I was just going to follow up. Thank you, Judge. Lisa, Jake brakes are on plumbed to motorhomes. My Dodge truck out there's got one on. I leave it on all the time. I hardly ever use my brakes. I mean, all fire trucks have them. Trash trucks have them. Washington County Road Department dump trucks, all their semis have them. They're factory. 90%. It's getting to where you can't even buy a semi without a Jake brake. It's kind of like a special order. It's kind of like the new pickups. You have to order a special order without rubber floor mats. I mean, a lot of them come equipped with them anymore because it's just standard. And it's a good safety feature. And if it didn't have the wording in here, it says Washington County within limits of all Washington County. If it just said your road at the red dirt pit, if that's all it said, I'd be happy with that. But that's not what it says. It says in here within the limits of Washington County. That's 990 square miles of what that's what that means to me. Is that not right, Patrick?
I would interpret it the same way. Okay. Justice Dennis?
Thank you, Judge. I always hate to put someone on the spot when they don't have a notice about it, but Sheriff Cantrell, could you come and speak to us about enforcement, how you would enforce this or how it could be enforced? It seems like that we have a lot of laws in our land today, and well, I just mean we have a lot of laws, and it doesn't seem like that we can enforce all laws. But anyway.
Sheriff Cantrell, do you have any commentary on this?
Well, it's a county ordinance, so the most severe enforcement will be a citation. There's and a fine. There's no jail time, I don't think, allowed by state law on a county ordinance violation. And county ordinances and misdemeanor offenses, with a very few exceptions, have to be seen by the officers. So they have to be committed in the officer's presence to take enforcement action. If they're not seen in the officer's presence, then the next process is to go to the prosecutor to fill out an affidavit to swear out a warrant and then get a warrant for arrest. So that's the enforcement mechanism. A deputy or a police officer would have to see it happen and hear it happen and be able to take that action at that time. The same with the muffler ordinance. Excessive smoke or noise from a defective muffler or anything like that has to be committed within the officer's presence, and they have to see it or hear it to be able to testify in court about it. So,
know of any tickets that have been given for the use of compression brakes?
No, there are some of the cities may have some city ordinances, but there's nothing in the county, so our county deputies wouldn't have done anything like that. And we have written warnings and maybe a few citations for excessive smoke or noise from a defective or faulty muffler, but those are very rare. Typically complaint-driven is usually how we enforce those, much like speeding or other traffic offenses. It's if people complain and indicate that they have an issue out there, then we'll try to direct some enforcement to that area. But keep in mind, 990 square miles or 950 square miles, whatever the county's actual size is, we'll have 5 or 6 deputies in that, work in that area at any given time, so we won't be able to saturate too much. with the manpower that we have.
Ever seen a ticket given for that?
For a compression brake? No, I have not. You know, our usual enforcement mechanism when we get complaints about dump trucks or the asphalt gypsies or whatever is to contact the Arkansas Highway Police, because they've got a lot of latitude to check a lot of different things that we don't have the authority to check, you know, safety checks and weights and measures and all the things that the highway police can check. So usually whenever they get through talking to particularly the asphalt gypsies, they will try to find someplace else to peddle their cheap asphalt. But once again, it's complaint driven.
Thank you very much. Appreciate it.
Justice Ecke?
Thank you, Judge. I believe what Justice Dean is trying to do is to bring awareness and attention to the problem that's going on in District 7. And it seems that if none of us have heard of this going on in our districts, this is a particular problem in his district, and he's trying to represent his constituents and his neighbors and friends the best way he can. The second question, so I support him for that. How many signs are we talking about? How many signs do we need to put up? There's different signs in Fayetteville that warn you and warn the drivers of various things that are going on in that particular neighborhood. So if my colleague would accept a friendly amendment to say, amend it to limited to District 7 and not the whole county, because that seems to be where the problem is. But I would still like to know how many signs are we going to be putting up. And I don't fault him for doing this, because there are certain streets in the city, and I live on one, where motorists just love to drag race. And there is a problem. And we've gone to the city council, and we have repeated with the roads department, and something needs to be done. So they put up all of these counting monitors saying, slow down. Average speed on a 30-mile-an-hour speed zone was 84 miles an hour. 50% of, actually it was 51 of the people were driving from 30 to 40 miles an hour. Everybody else was going faster. And we want to put up signs that say, slow down. Our children, pedestrians, cyclists, people are strolling their babies down the sidewalk. They're going to the lake. This is right off Turner going to Lake Road. So I support my colleague in wanting to do something and to bring awareness and feel like he's doing something to help his community. So if we have to discuss it a little bit more, but I'd like to make a friendly amendment to limit that to just District 7, but I would like specifically how many signs are you talking about? And what is the parameters around that? So if you'd accept that, I make a motion to amend.
I would ask for your help in, I understand that this is an issue that you're dealing with. To rewrite this for a particular part of the county, I would really like to take a moment. I guess what I'm trying to say is I'd like to extend this another month so that we can get with legal and make sure we could absolutely do that. I'm uncomfortable. I can't speak to us limiting it to a certain area of the county. So if you're open to that, Justice Dean, that's what I would like to do. At the risk of, I understand, putting it off another month, but I just want to make sure that we're doing something correctly. And we're getting quite a bit outside of my comfort level in terms of what we're capable of doing. And even if we were to agree tonight I would have reservations about trying to amend this and catch every
Certainly.
area of the ordinance to make it read like we want it to.
Certainly.
So I'm not trying to hold you up or anything. I just want to make sure that we're putting together our best foot forward.
And I would like the county to know that he is trying to do something to protect his District 7, and there's other of us are trying to do different things within the city, and it seems frustrating when the public just ignores the signs and the laws and they just insist on having their own way, and I understand that. So, thank you, Judge, for the time.
Let me see here. Justice Dean?
Thank you, Judge. I'd just like to say that in my district is Fayetteville, and they have posted a sign right up to the county, but not into the county because they can't. So it apparently is annoying somebody over there for them to have put a sign up. So it is illegal in Fayetteville. Thank you.
Justice Washington?
Thank you, Judge. So it seems that the noise is causing a disturbance, which is annoying to the people that live in that community. It also seems that we have concerns about the posting of signs as well as policing the use of these breaks. So I would like for us to table this to give Justice Dean an opportunity maybe to speak with the sheriff to see if there are other things that we can do outside of something as restrictive as saying we don't want you to use these breaks, as restrictive as posting a sign that maybe we can see if an increased presence in that area could help alleviate this. I would hate for this to fail because we're getting hung up on the use of the breaks and the signs because as Justice Eki said, I think that what he's doing here is looking out for the constituents in District 7. So I was wondering, I move that we table this for another month to give an opportunity for Justice Dean maybe to status with the sheriff to see if there are any less restricted things we can do in that area to alleviate this problem.
Okay. I have a motion to postpone for a month by Justice Washington, a second by Justice Lyons. Is there any debate on that motion? We'll take it up. Justice Lyons, would you like to speak to that? Okay. Any other comments on the motion to postpone? With that, all those in favor of the motion to postpone, say aye.
Aye.
Those opposed? That will be postponed until the next county services meeting. Thank you. All right. Next up, we have a couple of ordinances dealing with our Human Resources Department. I see our Director Burchett back there to kind of explain some of these. I think for the most part, these will be us coming into compliance with changes in other laws, if that makes sense, updating our stipulations, definitions, and that type of stuff. But first up, we're going to move to item number 8, an ordinance amending ordinance 2018-50 to update the family and medical leave policy in the Washington County Employee Handbook. Director Burchett, will you just introduce this for us?
Yes, this ordinance is to update our current existing FMLA policy, basically to provide employees, current and incoming employees, with the guidelines and the process and procedure that is expected of them in the event that they happen to need to apply for federal FMLA leave time. So,
Justice Eki?
I'd like to make a motion to approve.
I have a motion to pass item number 8 to the full quorum court with a due pass recommendation.
Be on the consent agenda.
By Justice Eki, a second by, did I hear Justice Dennis? Okay, thank you, sir. Any further discussion on this item? Justice Lyons?
Just confirmation. When I read through it, it didn't seem like there were a whole lot of content changes or some structure changes that made it maybe read a little better, more understandable. And as was pointed out, maybe references due to changes in other parts of ordinances, et cetera. In general,
that is correct. Yes.
Thank you.
Mm-hmm.
Any further discussion on this item? Justice Pond?
Yes, thank you, Judge. I've received some communication from some of the county employees expressing their concern that is there some way this ordinance or this amending this policy is going to reduce the number of sick leave days people can accrue over the period of the time of their employment?
No, sir. This has nothing to do with our sick leave policy. This is only the FMLA policy.
Okay, so this not gonna, maybe it's another ordinance that, or another amendment that you're coming up with where
We
they have to
discussed a
support-
sick leave policy in our JSAP committee, and it hasn't moved forward.
Okay.
So
You're not,
I'm-
you're not, okay, this doesn't have anything to do with, people losing sick leave days?
No, this has nothing to do with sick leave whatsoever.
Okay, thank you.
I think your comments were probably to that other policy that it didn't move forward. We're still working on it if we do anything with it.
It's not gonna be in this,
No,
okay.
At the
So-
risk of,
We're back to the drawing board.
I would consider that back to the drawing board. I mean, that's what JSAP's for, is to discuss things like that.
okay, well, I have no interest in discussing something that's not before us this evening. Thank you.
I was about to say it, neither do I. I understand that policy changes in our handbook and with our personnel can sometimes be somewhat controversial or open to a lot of debate. This is not a controversial topic. This is us just basically outlining FMLA. And in fact, I think we're communicating better to our employees what our expectations for them are and then what our obligations are as a county. So as vanilla and dry as this can be, we would just thought it was important to update it and get it moved into the current times. Further discussion or questions? Any public comments on item number 8? With that, we'll take up the question. I have a motion to pass the full quorum court with a due pass recommendation by Justice Secchi, a second by Justice Dennis. All those in favor? Aye. Those opposed? Item 8.1 will move to the full quorum court with a due pass recommendation. Item number 9, an ordinance amending ordinance 2018-50 to update the workers' compensation policy in the Washington County Employee Handbook. Director Burchett, will you run us through the cliff notes of this one, please?
So currently, our workers' comp policy in the handbook is very condensed. It doesn't give a lot of procedural guidelines for employees or supervisors or HR. So this policy breaks down the process. It's not changing anything. It's what we're already doing. We're just putting it in writing and then helping employees to understand the appropriate forms that they're going to be expected to complete and what's going to be expected of them in the event that there is an on-the-job injury. So essentially that is what the policy before you is.
I want to be corrected if I'm wrong. This one has a somewhat significant change that we believe is in the employee's favor, if that's correct, right? So one of the things we're running into is if an employee experienced an injury on the job, let's say a number of years ago, the workers' compensation will pay you 2/3 of your salary at that time. So if that individual is still employed by the county and has progressed and been promoted, their pay is still locked in at the moment of the injury. And so what we've done to change this policy up is to allow employees to take vacation and sick time to supplement the rest of that income while they're off, if they so choose to do that. Does that am I muddying the water up too much?
You sort of said that. So we can't.
That's why we hire the experts, Ms.
So
Burchett.
we can't change, the workers' compensation law, which they do pay 66 2/3 of the employees based off their gross wages at the time of the injury. So we can't fix that, but we can address the issue of an employee that whatever that difference is, the 33 and whatever thirds of their extra pay. Currently, right now, we don't allow our employees to dip into their sick and vacation so that they can get close to a full paycheck. And so that is one of the big accommodation rules that we're asking to be added to this, is so that we can start allowing employees to start utilizing vacation and sick in the event they have an on-the-job injury, so that they are able to still maintain their bills and everything like that. Even if an employee has a short or long-term disability policy, unfortunately in a workers' comp situation, that doesn't compensate them. You have to be completely without pay or income in order for 14 days following that for you to start dipping into that type of a policy. So unfortunately, even if our employees are participating in our health plan in that way, in an on-the-job injury, they're kind of stuck with that 66 2/3 pay right now. And we have had a few employees recently who have experienced that, and that's that's really hard on them. I mean, they're still having to pay their health insurance premiums for the county. If they're not able to, then when they return, we're having to get like double back from them. So this would just allow them to maintain their normal or close to their normal. Like I said, we can't do anything about that 66 2/3 that work comp considers, because that's their rules, that's law, but we can do something about that difference. And so this is us asking for that to be added in for our employees.
Great.
Does that make sense?
Justice Lyons?
Thank you, Judge. Make a motion that we pass this on to the quorum court with a pass recommendation.
I have a motion to pass to the full quorum court with a due pass recommendation by Justice Lyons and a second by Justice Dean. Any further discussion or questions? Justice Coe?
Thank you, Judge. Director Pritchett, I've been contacted by a couple of people, and I think there's some confusion. And one person says that this means that they can't go to their doctor if they want to go to their own doctor. The other person said, well, that's already in effect. So how does this affect the person? Say I was injured on my job and I wanted to go see my doctor, my primary care physician. Are you saying I wouldn't be able to do that from the...
That is correct. You would have to go to the county selected physician, and that is already a practice that we have into play.
That isn't...
So there's a reason behind that, and if you'd like me to get into that, I will. I'd be more than happy to. Whenever you have an on-the-job injury and you have an employee who's out of work, one of the big things is getting that employee back to active status, whether it be a modified accommodated status or not. Not always, but majority of the time, that PCP, that primary care physician relationship, sometimes that physician will just take the employee off of work and allow them to have time off of work. And so that ties our hands as the employer if we have a physician that is taking an employee off of work and not giving us not giving us restrictions that we can have the opportunity to try to accommodate. So for us, for our purposes as a county, as an employer, our goal when we have an on-the-job injury is to try and get that employee treatment quickly as possible, get them cared for, and then also be able to get them back to a place where they can return to active status and be on the job, whether it be in a modified situation or not. And there's financial ramifications if we don't do that. Having an employee sit on our work comp insurance hits us on the back end. So the benefit of having it where we are requiring our employees to go to our selected physicians is so that we have that working relationship with that physician for all of our work comp cases, so that that's our go-to. Work comp is a very lengthy, complicated process, and so we need a physician that understands what the county's needs are, what the employees' needs are going to be, so that we can get through that process as quickly as possible on the paperwork side. And the goal really is to get the employee back to work, to full active status, so they're back to normal duties. Sometimes that's not possible, but we need physicians that are going to cooperate with us, and that may not always be the case if it's an employee's PCP, their own personal PCP. So that's why when you see policies that say, okay, we're going to elect as an entity, these are our doctors that we're going to have our employees go to, and if they don't go, then there's the potential where they could be denied for their claim. Yes, that is a possibility. But if our employees are following the process, which is being presented to them in this policy, then that would not be the case.
Okay, excuse me. So we're not changing, that's already in the policy then?
The assigned doctors, we don't have that written in a policy, no ma'am, but we do send them to specific doctors.
Okay. Okay, thank you.
Justice Hires?
Thank you, Judge. I was just going to let J.P. Coker know, like, this is actually how it is at, like, the Fayetteville Public Schools, too. So if we're injured on the job, they're specific. I think it's fairly common. So I'm not a fan of it, but it's fairly common.
Any other questions or debate on item number 9.1? If not, any comments on item number 9.1? Public comments on item number 9.1? With not seeing any, we'll take up the question. I have a motion to pass item 9.1 to the full quorum court with a due pass recommendation by Justice Lyons, a second by Justice Dean. All those in favor? Aye. Those opposed? Item number 9 will move to the full quorum court. Before we move to the last item on the agenda, I would entertain a motion to move items number 8 and 9 to the consent agenda. I have a motion to move items number 8 and 9 to the consent agenda by Justice Lyons. I believe I heard second by Justice Rios Stafford. All those in favor of that? Aye. Those opposed? Items number 8 and 9 will move to the consent agenda at the full quorum court meeting. With that, we'll move to the final item on our agenda. We have a public comment period, a 12-minute public comment period with a limit of 3 minutes per individual. Any public comments this evening? Please state your name and where you're from.
Hello, my name is Jonathan Nunez. I live on Zion Road in Fayetteville, Arkansas. I want to take a brief second to thank Sheriff Cantrell for providing the space for the Judicial Equity for Mental Illness meetings that were happening this month in Washington County. Truly appreciate that. I think that there's great discourse that happened, and I invite all of you to come to those. And then second, I want to urge this body and in particular Judge Deakins to reinstate the members of the CJCC or find new people to appoint to that committee. Whether he doesn't, whatever he deems fit is fine. I just think that we need to get that committee back up and running as soon as possible and with urgency. I know that you're on top of that. I'm very anxious for that committee to come back and get up and going again. That's all I got. Thank you.
Thanks. Public comments. With that, we're